Good afternoon, everyone. My name is Jeremy Herman. I am an employment lawyer with Samfiru Tumarkin LLP. I'm located in Toronto, Ontario. It's great to be back with you guys. I've hosted many of these question and answer sessions for quite a while now. And as you know, we have question and answer sessions multiple times a week across all of our offices in Ontario, Alberta, and British Columbia. And the goal across all of our offices in these Q&A sessions is the same: to ensure that you, the public, are educated about your employment rights and to answer questions about your employment. And employment affects almost everybody. Most people in Canada are employed, and therefore we all have questions about our employment. This is the prime opportunity for you to ask those questions. You have access to me, an employment lawyer, for half an hour now, and I will answer as many questions as I can. As I typically do, I like to start off with a trending topic in employment or in employment law at this time. And what I want to talk about are layoffs, particularly at Amazon. We've spoken about this before, but this is something new. Amazon has announced that they are thinking about cutting about 14,000 managerial jobs. There's no definite plans yet to do it, but they have noticed that they have a very heavy managerial workforce, and they are thinking about cutting some of that managerial workforce in order to save on costs. Now, of course, how does that impact you? Well, if you work for Amazon, and you are in fact terminated, then you will be owed a severance package. It's very, very important that you have that severance package reviewed by an employment lawyer at my team, as part of my team, to determine whether the package is a good package. Most of the time, the packages that people are offered upon termination are not good enough. They do not meet the standards that are required under employment laws. This is just typically how employers do it. Some employees will sign on the dotted line right away and they'll accept the package, and they should not do that, because the reality is that in most cases, with the help of an employment lawyer, we can relatively quickly and easily get for you the severance that you're actually owed. So before you accept any package, ensure that you contact myself or someone on the Samfiru Tumarkin employment law team. Another important thing to note on this is that usually when an employer terminates an employee and they offer a severance package, the package will come with a deadline. And the deadline could be 5 days, could be 7 days, could be 10 days, could be 1 day. And as you can tell, from the fact that there are many different types of deadlines that employers use, there is no deadline that is real, that an employer is stipulating. The deadlines are a pressure tactic. That's what they are. The employer is trying to get the employee to accept the package that the employer wants to offer the employee right away and not negotiate. And so they put this deadline in there in order to put pressure on the employee to accept the deal. The real deadline that employees have is typically 2 years. You have 2 years to pursue your severance entitlements from the time that you're terminated. Much longer than the 1 day or 3 or 5 or 10 days that the employer is going to offer you in the severance package. So don't succumb to that pressure. Call us and we will ensure that you are provided with the severance that you deserve. So very important to note those things, whether you're from Amazon or just anyone else who's employed. Ensure that you don't accept those packages right off the bat. Okay, now with that, we'll delve into questions here. We have lots of questions already, which I'm very happy to see. We have a question from Finn on YouTube. I just started a new position. I was hired in my interview and they wanted me to start training immediately. I stayed 2 hours after my interview to train, then did another 6-hour training shift before being given anything to sign. At the start of my first official shift, I signed my contract, but my training hours have not been recorded. Is training paid, or should I not expect anything for it? Well, really, it will also depend. It will depend on whether the employer said anything about whether training is being paid. There are some times where it is, there are some times where it isn't paid. But really, what is important there is that the employer is forthcoming about whether or not your training hours are going to be paid. If there's some understanding that they're unpaid, then perhaps that's fine. But if there is an understanding that it's supposed to be paid and then you're not paid, well, obviously that's a problem, because there is a contractual agreement, even if it's oral, that you will be paid for your training hours. There are other issues that arise from this. I mean, it could be that you're considered employed right away once you begin your training, and then you're provided with a contract afterwards, after you've already started working. There's some issues there. You're supposed to have been provided with an employment contract and sign that contract before you actually begin working for the employer. This is actually a fairly common issue that I see in my practice, where employees are, they have some handshake deal. They start working for an employer, could be a week later or more, where the employer comes along and says, oh, by the way, here's your employment contract, please sign it. Well, that's a problem. That employment contract is arguably invalid because you've already began working for the employer. So without getting into the weeds of it, if this does impact you, if this has happened to you, or you're in the midst of dealing with this, absolutely reach out to us at help@employmentlawyer.ca, and we will ensure that things are dealt with in a legal manner. So Finn, I hope that answers your question. Very good question to start us off. Let's move forward. Okay. So we have a question on YouTube from P. Chan. P. Chan says that they work for a major bank for 15 years in a call center. It affected their mental health. They asked for an accommodation into a different role, and that was granted. But they were told that they only have 3 months to find another role. And then P. Chan went ahead and applied for many roles within the organization, but they haven't gotten any interviews. Just reading more from P. Chan. Okay, so trying to gather everything here, P. Chan, but it seems like your issue is one of accommodation. If you need an accommodation, of course, your employer has to accommodate you. Typically, you will have to provide some sort of documentation, and if it's medical, if it's a medical accommodation that you require, you're gonna have to provide documentation from your doctor or treating physician or treating health professional. It could be a therapist. It may not be actually a doctor, depends on the circumstances, but you'll have to provide some documentation to support the accommodation that you're requesting from your employer. And then once you provide that, your employer has a duty to accommodate you up to the point of undue hardship, is what the law says. That's what our human rights law says, undue hardship. That's a very high threshold. What that means is that most of the time, an employer is going to have to accommodate you in the manner that was prescribed by the medical professional. If it really is something the employer cannot do, and it would in fact cause them undue hardship, then the employer may not have to accommodate you in that case. But many employers think that they have reached that threshold of undue hardship, and really they haven't, and they have to apply the accommodations. So Pishan, I hope that helps. If you have a follow-up, definitely feel free to post it in the chat, and we'll get to it. Okay, we have another question on YouTube from Nompak. If I get employed by a friend and didn't have a contract, it was just verbal, When I asked for a proper contract, he fired me. Can I get severance? I worked there for 1.5 years. All I have are e-transfers. Yes, you can. You are not only employed if you have an employment contract. Very important for everyone to understand. You are employed even if it was just based on an oral discussion or a handshake deal. You don't need to have an employment contract in order for you to be considered employed. Okay, if you're performing work for an employer, you are an employee. And if you have an employment contract, great. If you don't, you're still employed. If you're fired, then you're going to be owed severance just like someone who had an employment contract. And in fact, you might be owed more severance because you have no contract that says how much severance you get. So the severance that you do get is based upon what the law says and not what the contract says. And often what the law says is going to give you more than what the contract says. Okay. And as you see on the screen, our pocket employment lawyer will help you with this. When we say how you're owed an X amount in severance, well, how do we determine how much severance a person is owed? When I said that the law provides you often with more severance than what an employment contract provides you with, well, what is that severance that the law provides you with? If you go to our pocket employment lawyer tool, we have what's called a severance pay calculator. The severance pay calculator is a free and anonymous tool. You can use it as many times as you want. Tell your friends and family about it. They can use it too. It will ask you basic questions about your employment and about you. It will ask you about your age. It will ask you how long you've worked for an employer. It will ask you what your position was, how much money you were earning or are earning. And then it will determine how much severance you're owed right away with the click of a button. Very, very amazing tool that we've developed. And like I said, it's free and anonymous. You can use it whether you've been terminated or have not been terminated, just to get a sense of what severance you might be owed. Okay, so going back to what you said, Nampak, if you've been there for 1.5 years, I don't know what position you were in or how old you are, but you could be looking certainly at a few months of severance, regardless of whether you had an employment contract. So feel free to reach out to us at help@employmentlawyer.ca, and we will assist you with getting the severance that you are entitled to. Okay. Let's move on. We have a question on YouTube from Glancing. I work as a financial planner, but I'm thinking about starting my own business. If I leave and some of my clients come with me, can I be sued or fined for this? I've not signed any contracts. Okay, so good question. If you have signed a contract, which many people have, that talk about whether you can solicit employees or solicit clients, then you're going to be bound by that in all likelihood, unless for some reason the contract is invalid. But let's assume it's not invalid. If you have signed a contract that has what is called non-solicitation provisions, then you're bound by those provisions. If you don't have a contract with those provisions, you're not bound by those provisions. It could be that you're sued anyway. It could be that your ex-employer will decide that you have infringed on their business and to an extent that they want to sue you. They may not have the best case if there's no contract, but they can still actually take legal action. Sometimes people take legal action. It doesn't mean that they have a good case, which is important for people to understand. But absolutely, you can resign. Glancing, if you do resign because you want to start your own business, note that you're not entitled to severance pay. You're only entitled to severance pay if you've been terminated, not if you resign. Okay. Be careful about taking clients or other employees with you because the employer could have legal recourse. Okay. We have a question we have a follow-up question on YouTube from P. Chan. Upon submitting all relevant documents for my doctor, my employer agrees that the call center is not good for their mental health. and they want to place you in a back office role. So, I mean, when they accommodate you, it has to be a role that is within your training and experience. They can't just place you in a role that you have no experience doing. That said, if it's something that you can easily learn and you want to be in that role, then that is something that you can do. Ultimately, it also depends on what you want. It may be that you're not obligated to accept a certain role, but if you want that role because you want to ensure that you have a job, you might want to take that back office role. It really will depend also on how different the role is from the call center role. I understand there's probably differences, but how different, right? And if it isn't so different and it's something that you can do, and it is within your medical restrictions, then that's a fair accommodation. Okay. If you want to arrange a consultation, I'm happy to do that. Just contact us at helpandemploymentlawyer.ca. I'll gather more information. I'll review the medical documentation, any correspondence with your employer. All of that is very relevant, and then we can talk more thoroughly. Okay, so DeRay, we have a question on YouTube from DeRay. They were terminated without cause after completing a probationary period of 3 months. Then you're providing me, DeRay, with all of these clauses. I'm not going to take the time right now to review these clauses from your employment contract. However, what I'll tell you is that if you are terminated without cause, you're owed severance. It could be that the contract limits you in terms of how much severance you get. After a probationary period, if you've been there for under a year, you're going to get 1 week of severance pay minimally. But you might be entitled to more. It will depend, again, on what the contract says. I appreciate you sending me some of the provisions of the contract. I'll need to look at the whole thing and perhaps more documentation. So, DeRay, why don't you arrange a call with us and we will set you up and review all the documents. Could very well be that you are entitled to more pay than what the employer is offering you. So just call us or email us at helpandemploymentlawyer.ca and we will arrange that call with you. What I can say, DeRay, is don't sign anything yet. If they're asking you to sign something, hold off, as I said in the beginning of this session, because you might be entitled to more. If you've signed something, I most likely cannot help you. So if you've accepted a deal, then you don't have much recourse. Okay. Okay, non-pack. Yes, you'll still be owed something, right? If you've been fired for any reason, really, you're going to be owed. Your severance pay. It's considered a wrongful dismissal. Even forget about the reason why you were fired, just the fact that you were not provided with the appropriate amount of severance or any severance. Okay, so definitely contact us. It sounds as though you certainly have a case. Let's move on. We have a question on Facebook from Dean. I was recently let go from my position as a server. My last pay stub was supposed to come in the mail, but I never received it. And my employer is saying that my last tip out was enough to cover this. Is that legal? Don't they have to provide me my wages because tips aren't included in that? Yes, absolutely. I mean, upon termination, you're owed all of your outstanding wages, okay, and vacation pay. So if you have worked for a certain amount of hours and you haven't been paid that, then you definitely are paid that. The employer can't decide now to withhold some of the wages that you've earned because they think you got a hefty tip. Whether or not your tips were hefty, if you are supposed to be paid a certain amount per hour, your wage, then you have to be paid that for anything outstanding upon termination. All right, good question. Okay, we have a question on YouTube from Demonic. I've been working for a month without having signed a contract, and I'd be forced to sign one from this point on. Good question. And I noted this earlier about whether your employment is valid or whether a contract is valid if you are asked to sign a contract after you've started working for the employer. So you don't have to sign it. It could be, though, that your employer is offering you something in exchange for signing it. Often what an employer will do is they'll say, we know you didn't get an employment contract when you started with us. It could have been a month ago, it could have been a year ago or more. But here's one now, and we're going to offer you a bonus, a signing bonus, in exchange for you signing the contract. Okay, you still don't have to sign it. Sometimes employees do, though, because they want to keep their job. And if you don't sign it, your employer may terminate you. Now, if they terminate you, though, you're going to be owed your severance pay based on what the law says you're owed, not based on what the contract says you're owed, because you never signed the contract. And what the law says you're owed is going to be based on, as we talked about earlier with the severance pay calculator, it's going to be based on your age, your length of service, the position you held, how much money you earned, and generally how available similar positions are in the job market. So that should answer your question. If you want to arrange a consultation, absolutely, we'll do that. Send me the contract. We'll go through it together. I'll advise you whether I think it's appropriate, and then we'll take it from there. Okay. All right. We have a follow-up from Glancing. He says, or he or she says, that their employer wants to retire and have me buy his book at the end of the year. It's a very toxic environment. He calls me derogatory names, etc. Well, that's, first of all, not okay. Of course, if your employer is creating a toxic environment and is using derogatory names, screaming at you, swearing at you, I mean, that itself could be considered a termination. It's what we call a constructive termination. It's not where your employer is saying you're terminated, but if they're creating such a toxic work environment and you can prove that, well, then that is a termination itself. So you might want to consider that. Okay. Let's see. We have a question on YouTube from Jackie. I've been working from home for 2 years as I've been accommodated because I had knee issues. The employer has a ground floor office now, and they want me to work 3 days a week. I've moved to the Niagara area. My job is in Barrie. I've been there for 10 years with no issues working remotely. I offered to take lower pay to work from home, but they said I would have to resign. All right, good one. Good question. So if you've been working from home for 10 years, and let's put aside the accommodation for a minute. If you were working from home anyway, and after 10 years, your employer says, well, now we have a brand new office. It also should be fine with, your knee issues because it's ground floor. So we want you to come in. Well, you don't have to go in then, okay? Because it's a term of your employment that you work remotely. However, all circumstances are different. So if you're a person who did work from the office for quite some time and you had an accommodation to work from home, or perhaps you worked from home due to COVID for a little while, and now your employer is asking you to come back to work because you don't need the accommodation anymore, and you agree with that, and your doctor agrees with that, or because the COVID pandemic is overall not so challenging anymore. People can work from the office now again. Then your employer can ask you to come back to work, okay? Because you started working from the office. It was due to an accommodation or rare circumstances that you had to work from home for a little while. But if you no longer require that, then your employer could ask you to come back to work because the employment term was that you work from the office. And we're seeing this happen all the time now. Many employers are reverting back to their working in office environment. Some full-time, some part-time, might depend on your position. Some positions, employers want you to come in full-time. Some say you can work fully remotely. It really, every company is different. Every position is different. But the point is that an employer can't ask you to come back. If you don't go back and you refuse, then you are resigning your employment and you're not going to be owed severance pay in that situation. But that is different from a situation that Jackie described, where Jackie has worked from home for quite some time. It became a term of employment that she works from home, and now the employer is asking you to come back. Well, in that case, you don't have to. And if they want to terminate you, they can terminate your employment, but they'll owe you severance pay. Okay, so everyone has a different story about this working from home, being asked to come back to the office situation. Every case is different. In some cases, it will be considered a termination. Some cases, it might be considered that you've resigned. In some cases, your employer may be in the right to require you to come back to work. In some cases, may not be. So ensure that you do reach out to us before you make any big decisions or any decisions at all about your employment in that regard. Make sure you contact us and we will walk you through it. We'll talk about the situation and we'll give you advice based on that. Okay, let's move on. We have time for a little bit more. Okay. Do you provide assistance to unionized employees? We do not, unfortunately. We provide assistance to non-unionized employees. Okay. We have another question. Can an employment lawyer help with a business partnership agreement? Perhaps it might require other legal counsel as well, perhaps a business lawyer or corporate lawyer. But if there are employment issues, then an employment lawyer would be involved with that. Okay, in the time that we have remaining, I'm going to talk about just an important topic, and then we'll likely end the session with that. So we have a legislation, a law in Ontario called the Working for Workers 5 Act. It's known as Bill 190. Ontario is introducing loopholes. Ontario is introducing legislation amendments to close loopholes. And the reason is because we're seeing that some employers, particularly there's one, and it's in the news, known as Dutchie's Fresh Market, they are they're having issues with paying employees, and employees are coming forward about this. And so Ontario wants to ensure that these loopholes are closed. And so they're making changes to legislation, to laws in Ontario to ensure that there are penalties for employers who do not provide employees with the proper wages, and known as wage theft. So this may not be, you may not work for this store, but if you are somebody who is not being paid properly or not being paid the wages that you're owed, as we talked about, someone asked about today in our session, that's certainly a problem. Could be considered a termination of your employment, certainly if you're not being paid for the work that you perform. So if you are in that, if you are facing that situation, ensure that you contact us. We'll arrange a call and we'll discuss it further. It was great being with you again. And again, my name is Jeremy Herman. I'm an employment lawyer at Samfiru, Tumarkin, and I wish you a great rest of the day. We'll be with you soon again.